Hello and welcome to the Independence Institute videocast channel. This is the inaugural episode of the Independence Institute's foray into videocasting and not podcasting. I'm glad you're here to join us. On our first ever episode, we have the great professor, the constitutional law master himself, Rob Natelson, is here to join us. And Rob, as the host of iVoices for many years, you and I have been doing podcasts for 3+ years, 3 years at least?
At least
3, maybe 4 years. 4 years. So I wanted to have you on because it's mostly you and I talking about constitutional issues, and I think the videocast is going to be you and I for a little while. So let's get used to this. I want to break you into our viewers and have our viewers meet you and understand where you're coming from and your background. If they haven't ever listened to our iVoices podcasts, I want them to understand who you are now if they start with the videos. You're a constitutional scholar, you're a lawyer, you've done it all. Where did it all begin?
Well, as you just said, my name's Rob Natelson. I was raised in the Hudson Valley area of New York State, came to Colorado as a young man, practiced law here. I've been involved in a number of private sector enterprises, both profit and nonprofit. In 1985, I decided, along with my wife, that I would like an academic career. Served for 25 years as a law professor at 3 different universities, and then finally took retirement, came back to the Independence Institute. And what I focus on is the U.S. Constitution.
And that was your focus when you were teaching law, correct?
For much of the time I was teaching, I had several different foci. In fact, that's one of the advantages I bring to the enterprise. Most law professors have a rather limited menu of courses, and they tend to teach them throughout their entire career. I had several different menus. I started as a teacher in the area of property and a few related courses, and then eventually taught off the constitutional law menu, including basic constitutional law, advanced constitutional law, First Amendment, constitutional history. But I also taught quite a few other courses in the curriculum, and this is not very common among law professors. Remedies, for example. I mentioned legal history, oil and gas, water law, various kinds of commercial law, contracts. So I developed a very wide understanding of the law, and this is important for constitutional studies because, while a lot of people don't know this, about 2/3 of the framers had themselves been practicing lawyers. And some of them did government work, but they also did things like wills and trusts and estates, which I also taught, and real property and contracts. So in some of the provisions of the Constitution, I've noticed things based on my background that others have not been fortunate enough to notice.
Yeah, so what I love about your background here at the Independence Institute and your position as the Senior Fellow of Constitutional Jurisprudence here at the Independence Institute is that you have such an extensive career in actually practicing law, which is somewhat uncommon with law professors, but also teaching a multitude of topics on law. And so you have this extensive history with a multitude of areas, and so I think your approach to investigating constitutional issues is much different than most people, and we will be getting into that. So what do you want?
There are 2 other things I would add here. When I was working in the private sector, I also employed people. The way we used to say it is I signed a check on both sides. Mm-hmm. I not only cashed other people's checks, I wrote checks for employees. So I know what it's like to be a business person. I know what it's like to create an enterprise. I think many judges and constitutional scholars tend to, while they think the political rights like free speech are important, they tend to underplay the importance of the economic rights protected by the Constitution because they've never done that sort of thing. They don't realize how critical they are. But then in addition to that, I have had a career on and off over 50 years in political affairs. So again, the same founders who practiced law and were involved in business and other fields of endeavor also were very politically active. And so sometimes I can appreciate what they were trying to accomplish with, say, a particular provision in the Constitution.
I mean, so your background is fantastic, and it's one of the reasons why I enjoyed interviewing you all those times for the last 4 years on iVoices.org.
And
when we
I've
had the
enjoyed being
podcast.
interviewed too, Justin.
I appreciate that. The other thing that I really enjoy is that your process for investigating constitutional matters is, I think, one of a kind, and I think is the correct way of doing it.
I don't know if it's one of a kind. It's unusual among law professors, but it's much more common among historians. In some ways, my methodology is more like a historian. Constitutional law studies in the law schools is infected with the attitude of, gee, I have to find things in the Constitution that I like and write about them, or I have to find some constitutional peg on which I can further my agenda, whether that agenda was universal health care or a libertarian agenda or whatever. There tends to be a tendency by law professors to always build a case, and that the actual meaning of the Constitution is often subordinate to the building of that case.
They have a conclusion in mind, and they're trying to gather evidence to reach a predetermined conclusion.
And that's not invariably true, but it is all too true, as one law professor, Professor Monahan, pointed out 30 years ago, that law professors seem too much dedicated to building a case and to actually getting to the truth. So what I do is I look at parts of the Constitution to see what's been written about them. And very often, and this is surprising after more than 200 years, but very often I'll find a part of the Constitution where there haven't been a lot of articles on it, or there have been, but the articles have not been very good. And sometimes these are fairly obscure clauses, like the Privileges and Immunities Clause of Article 4, which turned out to be much more interesting than you might think. But also the Freedom of the Press Clause. You would think that had been done to death, but in fact, there are certain aspects of it that I discovered that apparently other people had not seriously investigated. So I go into it, I look at, obviously I look at the text itself. I look at the transactions of the Constitutional Convention, the notes taken by people at the convention. I then look at the transcripts of the various ratifying conventions in the different states. I study the newspaper articles and the speeches that were written at the time of ratification, how these provisions were explained, both by proponents and opponents of the Constitution. Most famous sample of that is the Federalist Papers, which was written by proponents of the Constitution. But I go beyond that. I look at the 18th century law very often. A term like privileges and immunities, for example, is very common in legal documents at the time. What did it mean? I'll look at court cases. In two recent studies, one on the Recess Appointments Clause and one on the Origination Clause, which is a big point of contention now regarding Obamacare, I went deeply into legislative records, including the legislative records of the British Parliament and of the 13 original United States plus Vermont, which was operating as a separate independent state, and the Continental Congress, the Confederation Congress, and the First Federal Congress. So, and then I try to pull together from that a conclusion, or at least a range of permissible conclusions as to how this clause was understood. Justin, sometimes you can't always say, this is what it means.
Right.
But very often you can rule out some interpretations or limit the possible interpretations to 2 or 3.
Yeah, that's what I really enjoy about it, is that you pull from this vast array of resources and then you come to a comprehensive conclusion that touches on many different facets of what you're looking at in that time period. I mean, newspaper clippings and all that stuff is all there. And what we tend to discuss in iVoices are, here are the positions that people tend to stake out now that are patently false. So we know that for a fact.
Yeah.
And then here's this amalgamation of positions in the middle where that could be true, And
Sure.
so, but oftentimes, like we've discussed many times here, is that the two opposing polar opposite views tend to be quite often wrong to some degree. And then, there's the happy middle where, this all kind of makes sense according to all of these resources that we've looked at.
Yeah, well, let's use one example. Let's say the Establishment Clause of the First Amendment. Congress shall make no law respecting an establishment of religion. That has been subject to a wide range of claims about it. On the one side, there are those people who have taken the position that that the clause requires complete separation between religion and state. Two Cornell professors, I think, actually wrote an article called The Godless Constitution. Well, anyone who knows very much about the founding era knows that the framers, the founders, were overwhelmingly Christian. They weren't necessarily evangelical Christians, although some were. Some were Catholic. A few were deist. Some, like Thomas Jefferson, were Unitarian. But virtually none of them was wholly secular. And so that position doesn't stand up. And then on the other side, the position traditionally represented by the great Justice Joseph Story of the 19th century was that the United States is fundamentally a Christian nation, and that the purpose of the Establishment Clause was simply to assure that no Christian church was favored over other Christian churches, but Christianity could be favored generally.
Right.
Well, again, if that's the case, then why didn't the founders say so in the Constitution? Why is it that there's no reference to any religious test in the Constitution? Why is it that the Constitution, unlike the constitutions of all the states, didn't require that office holders be Christian, or at least subscribe to the notion that the New Testament was divinely inspired?
Right.
And as you just mentioned, the truth is very often in the middle. The truth is that this was founded as a theistic nation, so it was founded as a nation based on a belief in God and on providence, but within that sphere, all religions were to be treated equally. That's the real message of the Establishment Clause.
At this point in your career, you've done a monstrous amount of work, I mean, over decades now. Are you able to just pick whatever topic tickles your fancy at the moment? Or are you being told by somebody what to look into, or is it just like I wake up one day and I'm like, hey, I want to learn about I want to learn about the recess appointments, and then you just go into, or is it current event driven?
I'm not at the point of life where I have to be told, okay, or I can be told about it. And if you know anything about the scholarly creativity process, saying to somebody, you will research this and you will do a great job, is not really consistent with scholarly creativity. Certainly there are outside influences. For example, my friend and coworker Dave Kopel suggested, I think, 4 topics early last year that I might look into. And I found 2 of them very interesting, and I've since done articles on 2 of them. Some of them are driven by current events. For example, the Citizens United decision, which held that corporations can participate, or more precisely, people organized in the corporate form can participate in politics. That raised a tremendous outrage, so I became interested in it, and so I wrote an article about it, which is now pending publication. And what I discovered is that actually that part of the case that everybody, or so many people on the left, complain about was correctly decided. The part that the people on the left like was the wrongly decided part. That 8-1 decision, only Justice Thomas got that right. So, and then when the question of the Recess Appointments Clause came up, whether President Obama's appointments to the National Labor Relations Board were constitutional, I thought that was an interesting thing to investigate. But I've done many other topics where there doesn't seem to be much immediate need. For example, I did an article on the Indian Commerce Clause, which I published at the University of Denver Law Review in 2007, not because of any current events at all. I was just curious about the Indian Commerce Clause. And lo and behold, 6 years later, that is to say last year, Justice Thomas cites it in an opinion. So very often those things that I do write about that are not of current importance eventually get picked up by the courts.
I would love to talk about, real quick, about your citations. I mean, you have achieved a great, this is a great honor for anybody who does what you do, and being cited as many times as you've been cited. So tell our listeners about that.
Well, John Caldera put it this way. He said, getting cited by the Supreme Court is sort of the gold ring for you guys, isn't it?
It's true.
And
Yeah.
it is true. It is true. However, I want to give some credit here to the Independence Institute. I labored for 25 years as a law professor, and I was writing articles on constitutional law and constitutional history for over a decade of that period of time. Yeah, over a decade. And I was never picked up by the United States Supreme Court. What has happened since that time is my affiliation with the Independence Institute. The Independence Institute has built the infrastructure. Folks like John Caldera and Dave Kopel have suggestions as to how my work might have an impact or the kinds of things I might investigate. And frankly, the Independence Institute is a much more supportive environment for anyone who believes in free markets and free people than the unfortunately rather stifling, politically correct atmosphere of most of our universities today.
Academia. Yeah.
Yeah, exactly. Yeah. So, it's true I've done this work, but getting it out and actually getting it to the right people and the suggestions from folks like Dave have also helped. The Independence Institute deserves a tremendous amount of credit for the string of citations over the last year or so.
You're averaging like one a month over the last 13 months?
Well, it's hard to know how to count it. I mean,
two a month, something like that?
The Supreme Court first cited me in June of 2013, so June of last year. As we speak, it's July of 2014, and there have been 16 citations in 4 cases.
A little better than once a month. I mean,
yeah,
that is truly
however, the Supreme Court is not in session now, so I expect to fall behind that pace.
It's still, I mean, as it stands right now, this is a monumental
and just got a citation yesterday from the United States Court of Appeals for the 10th Circuit. Judge Gorsuch cited one of the first constitutional articles I wrote, one that was on the Republican form of government clause. I was really, this is the second, tied for the second highest court in the land, and so I was really glad to see that.
So maybe it's the Independence Institute could be thanked in the sense that we offer support, we've got your back, and we have this megaphone that we could use. The II has the megaphone.
Yes,
we just blast things out.
And that's true. And that's true generally about the Independence Institute for all of our scholars. I mean, we provide the kind of supportive atmosphere that you would not get anywhere else, and also the kind of freedom. I mean, I'm familiar with some other think tanks that can be pretty rigid. The kind of creative freedom that's allowed here is unique.
Now, before we wrap up our first ever video cast, I wanted you to briefly mention this book that came out, The Original Constitution, What It Actually Said and Meant. You can find it on Amazon. So tell us about this book and how this, was this the culmination of a lot of research?
This is the first book that actually looks at the Constitution in an objective way, as it existed, as the courts would have enforced it, in late 1791, right after the adoption of the Bill of Rights. So this looks at the original Constitution plus the Bill of Rights. And it's written for the layperson. So it's
even I can understand it.
Well, a lot of people can understand it, Justin.
Don't give me that much credit.
You can understand it. It's written for the layperson, and it's designed not so much to be read through as a book of reference, but it actually goes through the Constitution by theme. What did the commerce power really mean? What did the First Amendment really mean? What does the right to keep and bear arms really mean? And again, the guide star I use here is, how would a court have enforced this document in 1791 or 1792? Not just what the words meant, but also what would be the interpretive methods used. Mm-hmm. A lot of writers on the Constitution kind of make up interpretive methods in order to reach the results they write. The interpretive methods that I use are the methods that were well established at the time the Constitution was written, both in England and in this country, and methods that are referred to by writers, like the writers of the Federalist Papers. And so by using those methods and using the language of the Constitution and then the other kinds of sources that I talked about earlier, I'm able to reconstruct for people what the Constitution actually meant from a reasonably objective, impartial point of view, whether I particularly care for any particular result or not.
Right, and that again, that's what I really enjoy about your research, is that you may have opinions going in, and the conclusions that you reach sometimes are different than what you originally thought.
Right.
I mean, that happens quite often.
In some ways, it's a scientific method. I had an uncle, my father's brother, Samuel Natelson. I'm serious now about this. Who was a very noted medical researcher, whose research literally saved tens of thousands of lives, specifically of premature babies. And he was a scientist, and he would not have accomplished what he had accomplished if he had started with his conclusion and stuck with it no matter what the findings were. So I keep him in mind. It doesn't prevent me from starting with a hypothesis, but it's only a hypothesis. It is freely rebuttable, changeable, and actually in most cases it does get changed in some respect in the course of my research.
Well, Rob, I really look forward to interviewing you many times over for the Independence Institute videocast. Viewers, please check back to the Independence Institute videocast YouTube channel. We're going to have a lot of great stuff coming up, a lot of great stuff with me and Rob. So if you enjoy this constitutional talk and wonkery, and like I do, then please check back. Rob, thanks for being in the studio. I appreciate it.
Thank you, Justin.
All right, we'll see you next time.